Hello everyone. So guys, today we'll be discussing about economics of contract. So in economics of contract, what are the important components you need to keep in the mind as per from your exam perspective though, like in case on how you want to analyze the economics relating to the contracts that I'll be explaining in a very simplified manner. So what you need to do, just understand this. It'll hardly just take 2 pages, but once you understand this, you can put in your own words because it's very easy and very simplified. Okay, now let's get started without any further delay. Yes, now coming back into the first important component. So the definition says about in economics, contract is seen as a device for allocating efficiency, that is to allocate resources. Like basically, in economics, contract is seen as a device for allocating efficiency, that is to allocate the resources at its most effective uses. That means that how we can basically make a resources much effective. That's what anytime economics is trying to understand. If you don't understand it, I'll give an example. Okay, now I have a land. Now this land, I'm trying to utilizing it for different purpose. One, I can give it for rent. I'm utilizing that land for giving any kind of cultivation purpose. Now I'm utilizing that resources for the best of my ability, right? So resources tends to gravitate based on my needs, but depending on me, I can change it as per my conditions. That is what always economics is trying to understand. Now let's look it from the economics perspective. I hope now you understood this particular simple definition about how an economics is seen as a device for allocating efficiency. Now let's see on how economics is dealt with contracts. Now, if you guys observe, why this contract is basically formed. Contract are required for facilitating trade or for passing on risk between the parties or making transactions. Very simple, right? So now why a contract is important? Contract is very much important because of the simple reason that for facilitating trade, we can conduct trade. Second thing, for risk between the parties, even to manage the trust, between two people, we require a contract. For example, I have my phone in my hand. I'm giving this phone for you. Now what happened? I am giving this trust to you. In return, you're giving me money back. Now there's a contract. In order to protect this also, we require a contract, right? An agreement or any kind of rules and regulation. That is what economics is dealt with a contract. I'll tell you how it is dealt much briefly, but try to understand of what is a contract. It can help in making trade, risk between the parties, making transactions. It helps in all these three manners. One is facilitating trade, passing on risk, and making transactions. Now let's understand what are the canons of a contract law. That means that if I want to make sambar or if I want to make chapati, what are the ingredients for this chapati? Very simple, right? I'll be requiring flour, I'll be requiring so and so materials, I'll be requiring water, depending on it. Similar way, what are the components of a contract law? Very simple. Now if you observe what are the components of a contract law, first one, it should be voluntary action by both the parties. No, both the parties should basically accept for it. There should be a voluntary action between both the parties. Now I am giving my phone to you, you are accepting it. Now there should be basically be what? It should be a voluntary act. You cannot take knife and come to me telling that Pavan, you have to give me this phone, you have to sign this paper. No, it should be a voluntary act. Now second thing is maximizing net gains. Means I should also get benefited, you should also get benefited. Reducing transaction cost. It should be basically best of our ability of doing this contract between two parties. Fourth thing is about free consent. Now free consent, guys, trust me, it's very important. I'll just scroll the screen a little down, but you'll be able to understand this in a very simplified manner. Now what is this free consent? Free consent, if you observe very carefully, I can tell you that Amara, well, along with it, consent obtained by force cannot ever become a contract. That's the reason, I'm just highlighting this in red color once again. Anything obtained by force or that cannot be a contract, right? I'm telling you to go sign this. I'm telling you that with this knife, if you don't sign, I'm going to kill you. At such situation, if you write a contract, no, will that become a contract? No, that will not become a contract though. So anything consent obtained with force cannot become a contract. So contract ke liye one formula is always formed. That is what? Contract is equal to offer plus acceptance. Offer, it is proposed by me. Acceptance should be agreed by you. Only then that can become a contract. Okay. Now consent is very much important for any kind of contract. For any kind of contract, consent is very much important. Now silence cannot be mount to a contract. So guys, this point is very much important. Now why do I say this particular point is very much important? Why? Because if you observe very carefully, I'm telling you that okay, the person who's watching this video, just imagine your name is Karthik. Now I'm asking you, Karthik, you do one thing. Karthik, can you please sign this agreement? That time I'll be like, okay, fine, I will not speak anything. No, I'm silent over. I'm not giving my consent through my voice. I'm just being silent. Will that mount to be a contract? No, that will never be bound to a contract. So silence cannot ever become a contract. A contract can be come into an existence when there is an offer plus when there is an acceptance. If these two pillars are parallelly linked, then it can only become into a contract. Correct. I hope you guys got some kind of clarity regarding it. Now, if you mention about when we are mentioning about economics related to contract also, there are a few important sections which we need to note down. That's more about section 7 and section 8. Now, what is section 7 and section 8? I'll just clear it out. Now, what is the section 7 and section 8? So, section 7 and section 8 speaks about any kind of contract which you create, especially section 10. You cannot forcefully create any kind of contract or forceful or any kind of means, you're just, okay, you're trying to implement a contract through lawful object, only then it can become a contract though. So this is one of the important components which you need to keep in the mind, especially when we discuss about the law of contract. So contracting, these are the important criteria. One, section 7 speaks about acceptance, and section 10 is also saying about lawful object. See guys, we in contract we have already learned this before. Okay, for example, if I'm telling you see bro, I'm giving you rupees 10,000. Now in this 10,000 you're supposed to go kill so and so person. Now you killed that person. Okay, now we're coming back to asking me that, like, Pawan, I've killed so and so person, will you give me money? No, there's no point of me giving. Why? Because any kind of contract should have a lawful object. If there is no lawful object, then it cannot ever become a contract. Got it? So it cannot ever become a contract if it is, there is a, this one. So there is a lawful object. Lawful object plays an important role. Plays an important role in a contract. Okay, in a contract. So this is the important components which you need to keep in the mind. Now what we will do, we will go back to the next thing. Okay, next slides. Now, what are the remedies for a contract? So guys, what are the remedies for a contract? Again, what I want to tell is that what are the important remedies? One should be efficient breach. That means that government should try to introduce, like, how do you make sure that a contract will not become flawed, something like that. So government should try to introduce different kind of rules and regulations, many kind of laws. Law enforcement should be there, and different kind of laws and enforcement. If it is being brought up by the government, then we can make sure that that particular state is following with the proper amount of efficiency of contract. Just imagine that I'm promising you that I'll give you my land, but in return you have to give me 5 lakh rupees. Just imagine you're not paying me 5 lakh rupees, and by mistake I gave you my land. You're trying to acquire the land. No, there is a breach of a contract. When there is a breach of a contract, can that become validated? Breach of a contract. Breach of a contract. In order to be stopped, what do we require? We require rules. We require laws or laws. Now this is very much important. Breach, rules plus laws. So guys, this is very much important for us. An efficient breach. In order to stop this, only government is trying to introduce all this kind of rules and regulations. Now let's discuss what is unconscionability. Unconscionability means only when one party is getting benefited. That's called as unconscionability, or it could be like Pareto efficiency. Only when one party is getting benefited, that cannot become a contract, right? For example, I'm telling you that, Pawan, you can acquire my land, in which I'm just paying you only 500 rupees for it. It can be not possible, right? Only when one party getting benefited, that cannot always bound to become a contract. I hope now you understood some kind of important aspect about this entire chapter. So guys, that's all for today. Wishing you all the best. Good luck. Please do like, share and subscribe. Thoda encouragement karo yaar, so that I can literally help you guys. So that's it guys. Take care.